Hey guys, welcome to this YouTube channel. Please like, subscribe, and follow. Today, I'll be interviewing Catherine Maswati, a law student from Africa University in Zimbabwe, on exemption clauses. So, I've been curious on this topic for a while, and I decided to learn from the closest resource person I know. By the way, this is a topic under the law of delict. So, Catherine, what exactly is an exemption clause?
Okay, Tadiwa. So before I define the term for you, I want you to have a brief introduction. So, in today's business world, the term liability is a serious concern when making agreements. Henceforth, most contracts have exemption clauses in them as part of the terms of a contract. Do you understand?
Yes, I
Yes.
do.
So, the exemption clauses proceed with answers to questions to provide assurance on both sides on who is responsible for what and how that responsibility is to be determined. So, the answers of this question are mainly found in the exemption clauses, thus proving its importance in a contract. Do you understand?
Yes, I do.
Okay, so with this introduction, let me now explain to you what an exemption clause is. So, an exemption clause can be defined as a contractual term placed by one contracting party to exclude or limit intellectual liability to the other contracting party.
Okay.
Do you understand?
Yes, I do.
Okay, so what I'm trying to say is an exemption clause is the what if part of a contract, meaning that exemption clauses explains the consequence of breaching agreement, unsafe behavior, or any other variables that may occur. For example, parties can exclude or limit liability for negligence, breach of contract, or delictual damages. Do you have any other questions?
Any categories of exemption clauses?
Yes, there are two main categories of exemption clauses. And the funny part is that these categories are even listed or they're even found in the definition. Remember, when I defined the term, I said an exemption clause is a contractual term placed by one contracting party to exclude or limit. So they are the categories are exclusion and limitation. Let me explain to you what a limitation clause is. A limitation clause limits a party's liability for something. For example, parties may use a limitation clause to limit the amount of money they are responsible for paying in damages if certain events occur, like breach of contract. Do you understand?
Yes, I do.
Okay. So, on the other hand, there is exclusion clauses, which is another category. Do you understand? Okay, so an exclusion clause excludes a party from liability, meaning that they take away responsibility either partly or completely. Okay, so its purpose is to protect a party from any responsibility regarding a specific event. Do you get it?
Yes, go on.
However, you have to note that courts tend to look favorably on limitation clauses than exclusion clauses, as they take away responsibility.
Okay.
However, in line with this, common law approaches the exclusion clause as valid, and the reason is that people should honor the obligation they enter freely.
Oh.
Do you understand?
Yeah, I do.
Okay.
Oh, so what you're trying to say is that an exemption clause refers to the what if part of a contract, and there are two categories to it. That is limitation and exclusion. Am I right?
Yes, yes, you're right.
And you also said an exclusion clause is valid as long as there are no factors which vitiate a contract, like fraud, duress, and misrepresentation.
Yes, that's right.
Okay, I understand, but I have a question.
Okay, what is the question?
What are the principles of exemption clause?
Okay, so what you have to understand is that Zimbabwean courts have adopted rules designed to limit the applicability of exemption clauses. So in the case of Tube versus Mwamuka, the court stated the principles applied in exemption clauses, which include whether the exemption clause is part of the contract. So the exemption clause should be part of the contract. Do you understand?
Okay. Yeah, I do.
Okay, so the second one is the words of the exemption clause must be read as part of the contract. It must be sufficiently clear for the court to give effect to them. So what I'm trying to say is if the clause is ambiguous and it will be interpreted against the drafter, and this is known as the contra proferentum rule. Do you understand?
Yeah, I do.
Okay, so in the case of Cotton Marketing Board, the court ruled that the exemption clause must expressly specify that a party is exempt from liability resulting from its own carelessness. Do you understand? So in addition to that, in the case of Cabri, it was held that an exemption provision that limits or excludes liability or negligence in a customer contract could not be enforced. Do you understand?
Yeah, I do.
Okay, so let me take you back to what a consumer contract is for you to understand what we are saying. So it is important for you to know that a number of jurisdictions have enacted laws to safeguard consumers from the inclusion of unfair exemption or restriction provision in a contract. However, when it comes to consumer contracts, this position is different. The position that I'm trying to explain to you is the one that I've said before. I started to explain about the consumer contract. Okay, so what I'm saying is in Section 2 of the Consumer Contract Act, it defines a consumer contract as a contract for the sale or supply of goods or services, or both, in which the supplier is is dealing in the course of a business. Do you understand?
Yeah.
Okay, so judges have also created rules to limit the harshness of exemption clauses, which, with the aid of the Consumer Contract Act, like I've explained, and the court have ruled that one cannot limit his liability from his own negligence act. So if I enter into a contract with you and you act negligently, you cannot be exempted because of it. Do you understand?
I understand.
Okay. However, you should also note that there are some instances which make a person not delictually liable, and the circumstance includes inevitable incidents or accidents. What I'm trying to say is, if the harm resulted from an event in nature, like floods, drought, and some other outside force over which a person had no control, that person will not be delictually liable. This sort of event, such as a flood or damage caused by wind, is variously referred to as an act of God or an act of nature or a vis major. Do you understand?
Yeah, I do.
Okay. Okay, Tadiwa, as a former law student, do you have anything to add on?
Yes. In addition to what you have said, I read that there is an issue of public policy which makes a person not delictually liable. For example, in cases where a person has suffered damage as a result of his participation in an illegal enterprise, the court may hold that it is contrary to public policy to allow him to recover damages from a fellow criminal who caused him loss. In the case of Murphy versus Tingende, the court held that what person P had done was contrary to public policy, hence, he was liable.
Okay, Tadiwa, thank you for your contribution. It was very, 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 very useful and very important. This is all that we had. Okay, and some of the concepts are going to be expurgated by the slides to follow.